Hello. Welcome to, I don't know, I'm going to call this Barkin while Parkin. We could also call it Jiving while Driving Part 2. The Reckoning. So I've had some interesting comments, and I would like to address them because I think the class may learn from it. Not that any of you have class, but what are you going to do? It's a joke, kids. Relax. The first statement that was made that I feel I need to address is that if I, John, don't believe that Freeman committed a crime in Leon Valley, then doesn't that mean that Salvaggio is ignorant of the law? And it does not. Number one, ignorance of the law isn't relevant to this discussion, but it doesn't make him ignorant of the law. There are lots of squishy areas in the law, gray areas, that are very fact-based, and it's you're never going to know whether or not you're right or wrong until you get in front of a judge. You just can't. And so if he's in one of those gray areas, I wouldn't know it. I'm not a licensed attorney in the state of Texas, and I haven't seen the evidence, so I just can't tell you. I would like to point out, though, that the district attorney and 2 or 3 judges have all agreed that there was probable cause, because the first judge, the magistrate at the probable cause hearing, said there was probable cause, and then there were 2 warrants issued on Freeman in connection to Leon Valley. And warrants issue when you show a judge that there's probable cause that evidence of a crime is going to be turned up by that warrant. And that's the standard. The standard is probable cause. A police officer can arrest you if he reasonably believes that a crime has been committed and that you committed the crime. So it's a very low standard of proof, and he doesn't have to know exactly what crime was committed. Indeed, he may not have any clue what crime was committed. He may just have a reasonable belief that somebody did something terribly and horribly wrong. And he could let the DA sort out the details later, because that's the role of the DA. It's not the role of the cop. Cops have to have a good understanding of the statutes and ordinances, but they don't have to know them off the top of their head, and they basically have to have good common sense, and they have to be reasonable. That's basically where it lies. So ignorance of the law doesn't come into play, and it's completely the wrong standard to apply. The second thing is related to the first. Someone made the assertion that police should be responsible for their own actions, and they should be responsible if they commit a constitutional violation, and I'm just following orders shouldn't apply. And while I agree with that fundamentally, there is one caveat to that the person didn't include that I think is, well, first of all, it's supposed to be there, and second of all, it actually makes a lot of sense to have it there, and that is that until a court has determined that it is a constitutional violation to do X, Y, or Z, then the cop can't reasonably know that it's a constitutional violation to do X, Y, or Z. That's why in the Turner v. Driver case, those cops, it wasn't clearly established in their circuit, and so now it's been clearly established, and now if a cop does that, now he should be held responsible. That's the difference. That's the missing ingredient. Again, cops aren't lawyers. Cops are members of the executive branch. They're part of the executive branch of government. Their job is to enforce the law. It's not to interpret it. It's not to write it. It's not to repeal it. It is to enforce the law. Interpretation is 100% the bailiwick of the judiciary. The judiciary interprets the law. Once the judiciary decides that something is or is not constitutional, then we know. Until we know, we don't know. Because we're not, like, I can't predict what a judge is going to do, what a court is going to do. I can make an educated guess based on my knowledge and case law, but there is no guarantee ever that anybody's going to know what the court is going to do. So you got to wait to know what the court's going to do. And until the court has firmly established that something is a violation of the Constitution, then you can't reasonably expect the officers to know whether it is or isn't. And we don't want them paralyzed with fear. It's their job to enforce the laws, not to be paralyzed with fear over whether or not this may someday be found to be unconstitutional. Notice a pattern. The cops are supposed to be cops. They're not supposed to be judges. They're not supposed to be juries. And they're not supposed to be lawyers. They're supposed to be cops. And they're not supposed to be legislators. They're supposed to be cops. Finally, once again, we return back to duty to protect. I have made full-blown videos on this, citing case law, and I will try to give this to you in a nutshell. What the Supreme Court has held is that the 14th Amendment Equal Protection Clause does not, actually the 14th Amendment in its entirety, does not grant a cause of action for individuals to sue the police for a failure to protect them. And each one of those words is important. The 14th Amendment specifically, which means that another statute could, but the 14th Amendment doesn't. The 14th Amendment does not create a cause of action. You can't sue somebody for a 14th Amendment violation for failure to protect you as an individual. That does not mean that the police don't owe a duty to the public. The public is owed the duty of protection. And you say, well, I'm a member of the public. Congratulations, but you aren't the public. Every day, every single person sloughs off hundreds of thousands or millions of skin cells. It's just gone. Every day. Those skin cells aren't you. If someone takes one of those sloughed off skin cells and destroys it, it's not you. You are like a cell in society, in the public. The police don't owe you as an individual a duty of protection. You can't sue them for breach of a duty under the 14th Amendment. The public as a whole may have some recourse. There's a reason why sheriffs typically have to provide a bond. It's in case they screw the pooch. That's a technical term. That's legal jargon right there. And the Supreme Court has specifically stated that while the 14th Amendment does not act as a font of tort law, states can craft statutes that will allow for a cause of action against a police officer for failing to protect an individual. But that, again, doesn't mean, even without one of those statutes, it doesn't mean that the police don't have a duty to protect you. They owe a duty to the public to protect the public. Imagine, if you will, that the police had a duty to protect each individual. If person A starts a fight with person B, who do the police protect? Well, if they owe it to both, then they're screwed. So they don't owe it to the individual. They owe it to the public. If the police don't protect the public, there are lots and lots of methods by which they can be dealt with. So in summation, as far as all of these points are concerned, number one, Salvaggio could arrest on probable cause that a crime was committed and that Freeman committed it. I would submit to you that it appears, based on the 2 to 3 probable cause hearings, well, 3 probable cause hearings in front of 2 or 3 judges, it would appear that Salvaggio had probable cause. Number 2, the police aren't lawyers. They're not judges. They're not courts. They don't get to decide what is or isn't constitutional, and until they are informed of what is or isn't constitutional by the courts, you can't reasonably expect them to be psychic and predict what the courts are going to do. Lower courts can't always predict what upper courts are going to do, which is why lower courts are overturned from time to time. If a judge can't predict what another judge will do, how can a cop? And point number 3, the police have, law enforcement has a duty to protect the public. They do not have a duty, as far as the 14th Amendment is concerned, to protect an individual. And so you say, again, now that we've gotten through that, I can hear people not getting it. So I'm going to say it once again. If you are the victim of a crime, the police will help you. If you call and you say that there is someone bad outside of your residence, the police will respond. If they don't respond fast enough, you can't sue them for it under the 14th Amendment. But they will respond. And if they fail to respond at all, maybe under state law, maybe there is a course of action that you could take to sue them. Maybe. But you can't sue them under the 14th Amendment. I hope that helps. I hope that clears it up. I know I'm going to go over it again in the future, but hey, you know, I like talking about the law. Thanks for watching. Have a great day.